The nation's highest court will decide how far the government can reach when it comes to your cell phone. Today, the Supreme Court announced it will rule on whether or not warrants are required to get information from cell phone companies about customers' locations.
News 4's Jen Sean spoke to a local attorney and sheds light on what's at stake here. Jen?
Well, Don, Carpenter versus the United States is all about whether or not moving forward, police should be required to obtain warrants before gaining access to phone location records. There's a state bill going through the ranks that would allow officers to use a device that could tell them which apps were open on someone's phone and how recently. Both are part of a new legal debate. What deserves to be private in the digital age? Monday, the Supreme Court announced it's taking on a new case, Carpenter versus the United States.
They're getting a lot of requests from lower courts. A lot of federal courts, even some state courts are looking at that issue.
That issue is how private our devices deserve to be. The original 2011 case from Michigan relied on location records from a cell company without a warrant. Those records helped the prosecution link Timothy Carpenter to the location of a robbery. If the Supreme Court rules in favor of Carpenter, the case would not only be retried, but moving forward, law enforcement would need warrants to search cell location records. They wouldn't need your device in hand to do it. Past Supreme Court cases have ruled against claimants like Carpenter.
And those Supreme Court cases seem to indicate that we don't have an expectation of privacy in where our phone is located because we know that the carrier collects that information and therefore we know that a third party has that.
But defense attorney Barry Covert points out those cases were before phones carried the personal information they do now. Here in New York, legislators are considering approving a device for law enforcement to crack down on distracted driving. By connecting to a phone, it would show if any apps were open during the time of an accident and for how long. According to the app's developers, no personal information would be gathered.
It's gathering all of your information. Then it's filtering out, allegedly, only the relevant information that they want. You can always change filters.
The ACLU is the co-counsel in the Supreme Court case. I've reached out to them and haven't heard back yet. The New York branch of the ACLU has voiced concern that the textilizer bill is being rushed. It was approved by the Senate's Transportation Committee in March. State police will not weigh in on this yet, given that it's still going through the legislative process. We'll keep you posted on both of these stories. Live in the studio tonight, Jen Shantz, News 4 at 6.
Jen, thank you so much.